As the space community endeavours to become more ambitious, the legal profession and others will need to adapt to a new space age. As space technologies become more advanced, our society will be required to become more educated and scientifically literate. The legal profession must be more scientifically literate to address the legal problems affecting human activity beyond Earth's atmosphere. Presently, the law is incomplete and unprepared to address the challenges of deep space activities. At present, COSPAR has constructed a planetary protection policy, and NASA has a planetary protection officer. However, COSPAR and other intergovernmental organisations must work together to establish a sound legal framework to reduce the spread of biological and non-biological contaminants. An interdisciplinary approach is necessary to ensure that the common good is being addressed regarding the appropriate quarantine procedures are being followed to reduce the likelihood of potential life, whether in a solid, liquid or gas form or any other form. Also, a specialised international space court with an appropriate jurisdiction is recommended to fully comprehend the complexities of space science and the law surrounding it. The need for scientific literacy is definitely needed, not just in law but in other professions. Scientific literacy requires an individual to approach a problem or decision acknowledging appropriate evidence-based knowledge. By proposed a framework of 4 levels of scientific literacy: nominal, individual having an adept knowledge of scientific term, question and topic; functional, individual uses correctly the scientific literacy in the correct forum; and the concept perceptual, an individual can apply scientific theories and principles whilst understanding the whole of the discipline. Multidimensional, an individual understands the science, history, purpose of science in all facets of society while having an interdisciplinary approach. A regulatory perspective on the differences between scientists and law. A key concern for more scientifically applicable laws is identifying the issues associated with the scientific problem in hand. To best address the scientific problems, both scientists and other STEM professions must work together to ensure that the appropriate measures are enacted in law. However, difficulties occur due to communication breakdowns, timing, and funding constraints. Howard Green, a law professor, identified that lawyers are perceived by scientists as having little capacity and having difficulties engaging scientists on how to best handle the public policy issues. Time and financial constraints greatly affect lawmakers and primarily use scientific knowledge to support their policy approach or legal arguments, but are impatient regarding the development of new evidence and unlike scientific researchers. Now, a judicial approach to scientific problems. The United States legal system, much like the Australian legal system, does not allow judges to act as legislators or scientists. Also, judicial discretion is constrained by the Constitution, the standards of the legal profession, legal precedent, and the rules of legal reasoning. However, judges are conspicuous of the legal principles and practical considerations of the world. The 2 main approaches to solving the scientific legal problems are as follows. 1. The court reviews the actions of administrative agencies and must consider all the relevant factors to determine the administrator's decision. 2. The court in practice cannot avoid scientific and technical issues, and that's due to the courts acquiring an understanding of public administration decisions. Most people generally think they struggle with the scientific issues and they try to avoid them as much as they can. But much like space law and the tobacco regulatory science, which is interdisciplinary, it requires judges to consider both the scientific issues and the regulatory issues and how research can be applied to this. The R.J. Reynolds case is therefore crucial that lawyers work with scientists from the beginning of the research process to best determine the appropriate legal test and ensure that all questions are addressed through the research in the courtroom. The current environmental law concerning the common good for reforming the planetary science space exploration. The judiciary plays a key role with recognition of the United Nations Millennial Declaration values of freedom, equality, solidarity, tolerance, respect for nature, and shared responsibility. The judiciary also plays a pivotal role in promoting environmental governance, upholding the rule of law, and ensuring a fair balance between environmental, social, and developmental consideration for its judgments and declarations. Agenda 21, the Programming of Action for Sustainable Development, the need to provide an effective legal and regulatory framework. Laws and regulations are made via command and control methods, but with the recognition of developing a sound environment policies. To develop laws and regulations that are based upon social, ecological, economic, and scientific principles. The UN World Charter for Nature, although not binding on an international legal document, but it has significant political weight, and some of its principles can be adopted into interplanetary space law policy. The implementation section of this charter calls for the incorporation of its principles to be applied in different jurisdictions, and governmental and non-governmental organisations also should incorporate the principles as well. Also in 1991, the International Union for Conservation of Nature prepared and published the Caring for the Earth, a strategy for sustainable living, which defines actions necessary to achieve sustainable development in various ways that can also be applied to planetary contamination. One recommendation that should be included in the space law regarding planetary contamination is the precautionary principle to develop new policies concerning environmental impact assessment. The Rio Declaration Principle 4. In order to achieve sustainable development, environmental protection shall constitute an integral part of the development process and cannot be considered in isolation from it. Principle 15 of the Rio Declaration, the precautionary principle, is as follows. In order to protect the environment, the precautionary approach shall be widely applied to states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. Now, the barriers of reform, in short, lawyers are not scientists. We can't devote that amount of time into that in legal practice as well, and it's just not our specialty. So a problem for the legal system, particularly when understanding the practicalities associated with space law, is determining sound explanations. And in particular, with one new area of law that requires specialisation, it cannot provide the opportunity for lawyers to invent reasons offhand for whatever the judges find to be established in law. An important consideration for the law in this area is to have a practical technical definitions of terms such as legal form, biological contaminant, non-biological contaminant, sample returns, special regions which are referred to in the Planetary Protection Guidelines, restricted earth return, sterilisation procedures, unsterilised samples returned to Earth. By having a hard law that enacts these terms into legal terms would be addressing 1. What, where and how a space object, whether that's a lander, orbiter or a probe, have reduced or eliminated the risk of contaminating Earth or other celestial bodies, and to what extent. The questions relating to all planetary protection documentation, including but not excluding mission planetary protection categorization and planetary protection plan, will make lawyers more informed of answering the legal questions. Another important question for a space agency or private operator hybrid is the review of reasonableness concerning all the relevant planetary protection plan and all hardware components and equipment used on the spacecraft and the risks associated with extracting a biological organism, the likelihood of contaminating Earth and other celestial bodies, all the risks of spacecraft, its instruments interfering or contaminating possible life forms. So how is science applied in law? One of the best statutes that I know of is the United States Federal Rules of Evidence 1975 Rule 702, which I recommend people to look up in their own time. In Durbet versus Merrill Dell Pharmaceuticals, a 1993 case, provided a non-exclusive checklist for trial courts to use in assessing the reliability of scientific expert testimony. And they formed the following factors. One was whether the expert technique or theory can be or has been tested, that is, whether the expert's theory can be challenged in some objective sense, or whether it is instead simply a subjective and collusory approach that cannot reasonably be assessed for reliability. Whether the technique or theory has been subject to peer review or publication, the known or potential rate of error of the technique or theory when applied, the existence and maintenance of standards and controls, and whether the technique or theory has been generally accepted in the scientific community. And Camo Tire Company and Carmichael, which is 1999, held and supported these factors were also applicable in assessing the reliability of non-scientific expert testimony should be treated on a case-by-case basis. In Debris, the Fryer test, which is general acceptance test that is dominant standard for determining the accessibility of novel scientific evidence at trial. Frey test, just when a scientific principle or discovery crosses the line between the experimental and demonstrable stages, is difficult to define. Somewhere in this twilight zone, the evidential force of the principle must be recognised, while courts must go a long way in admitting expert testimony deduced from a well-recognised scientific principle or discovery. The thing from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs. So, in conclusion, both the legal and scientific community can work together to achieve common goals concerning the appropriate regulation of planetary sciences to prevent planetary contamination. An interdisciplinary approach is required to determine the best way to mitigate and regulate planetary contamination, both from man-made objects entering a celestial body or from man-made objects returning with biological or biological samples. And the legal profession as a whole must meet the demands of a new space age and will need to become more scientifically literate, and our laws will need to be to best address the concerns of space travel. A specialised international space court is required to adopt an interdisciplinary approach to space law. And just an example of what the space community needs to really assemble in regards to the common good for planetary contamination and to prevent a spread of or an outbreak is based on a great example is from Andrei Sakharov on the Russian intellect, that it is not focused on the academic or economic status, rather he or she dedicates their time to social or moral objectives. Social and moral objectives that improve the common person, eliminate the social evils, e.g. greed, and has a moral imperative to expose the truth regardless of their consequences. He or she strives for perfection and has a duty to sacrifice their beliefs above their self-interests.